Uh, Hi, it's Nathan Willner with the NCBA, and I'm excited to welcome Joel Rosenthal, Vice President of Head of Credit Collections, Business Development, and Client Relations for ProVest, again to another episode of Coffee Break. So, thank you, Joel, for joining us again. We're really excited to have you here.
Thanks, Nathan. I think this is like the third or fourth time we've done one of these over the last few years, and really appreciate the opportunity to be able to participate in your educational sessions.
Yeah, I know we're excited to have you here with us. I'm going to go through a couple of basic questions about what's been going on in the space and what where Provest has been really involved. So let's kick it off with a kind of a basic question. At what stages of the litigation process can skip tracing be useful?
So today we're going to be talking solely about skip tracing. That will be our educational topic. So just to give a headline to it, so people don't wonder why all three questions or four questions or whatever you're going to ask me are going to be on skip tracing. So yeah, to answer your question about like what stages of the litigation process can skip tracing be useful, I would say it breaks down into three different buckets, and it's typically tied to, sort of inventory buckets. The first, in doing it chronologically in the litigation process, the first time would be uh, what I would call a pre-suit skip tracing. So somewhere close to before the documents are cut.
And
You're
Joel, before we get into the details, maybe for those listeners that maybe aren't that familiar with what Provest does, maybe explain like what skip tracing, like we use that term all the time, but what
right.
is skip tracing? Let's
Okay,
start with
let's
that.
start with let's go even further back. Okay,
Right.
good idea. So skip tracing is in the case of what we're going to be talking about, because there's skip tracing for all different sorts of things, but we're talking about address skip tracing. So in the concept of collection litigation, in nearly every state, you have to serve legal papers, whether it be a private process server company like ProVest, or in some cases a sheriff or constable. You're going to have to give notice in effect to the consumer that they are the party to litigation. And to do that, you have to have an address to locate them at. And furthermore, based on FDCPA rules, you need to be in the right venue so you don't get into trouble with, being outside of the federal rules and regulations on that. So a good address is going to lead to a smoother process, avoiding pitfalls and added costs.
And while I'm sure many of these accounts come, have some address affiliated with them, but of course you can't just rely on that because people move and could move many times since the original account was open. So it might sound really simple, especially with technology nowadays, to just find where someone lives, but it isn't that simple, is it?
No, it's a sort of a science, and no matter how you do it, the quality of that leads to better results. But then, as in anything, better quality can cost more. So it's a fine, it's sort of a fine balancing act that you have to take. But let me circle back to your first
Right.
question.
Okay. Okay.
Your second question was a good first question. I'm glad we got to that. But to your original question that you asked is sort of at what points does skip tracing make sense in the litigation process? So the first area chronologically would be what we would call pre-suit skip tracing. So sometime right, prior to the documents getting cut. Secondly, would be after it's been documents cut, filed, it's now with a process server. When they encounter a bad address, meaning the consumer does not appear to live at that address, there would typically then be a second point of opportunity for skip tracing, which would be when it's actively placed with a process server to skip trace, whether the law firm or litigator does that or the process server does that, the
Hmm.
process serving company does it. And then the third point would be after the files have been, any that were not served to a consumer, they then go back to the law firm or litigator's inventory. And typically there's going to be skip tracing done to locate a new address, because not only do they have the account in their inventory, but they've already invested the cost of suing. And so they have to move that back into an active status, you need to serve the person and you need to identify an address. So doing that on a regular basis after any non-serves is very important to, manage your inventory.
So just to like a recap, basically there's three different stages that you've identified where your due diligence is going to make a difference on the outcome, right? In other words, before the documents are finished, once they're ready for service and they're being sent out to the process server or whatever means you're serving the consumer by, and then finally following that to make sure that again the person hasn't moved and that nothing's changed. So the question then becomes, at each one of those three stages, does it make a difference? Like, would there be a lift in terms of service rate percentages based on this kind of due diligence and best practices?
Yeah, that's a great question because it's one thing to do it, and then what is the outcome of that? So let's circle back to each of those three time points and talk about what the impact would be. So on the pre-suit skip tracing, it's a little hard to put like a percentage lift in the service rate on that. But what it's basically doing is it's weeding out files that are really out of state. So the person no longer even lives in the state. Second, it's identifying any that are in a different venue than you thought, so that you're going to file in the correct venue. It's eliminating potentially ones that when you do skip tracing, X% of them come up with no current address, or there's an address that the most current one could be 6 or 12 months old. And so the quality of that address may not be great. So you can target or weed out those based on what you want to do with your process. So, and there's a few other nuances to the whole thing, but I mean it's a way of targeting better, so you're not wasting your time and money and going in the right place with as many of them as possible. So that's on the pre-suit. On the other two areas, I could give some numbers. So the ones that are actively placed with process servers, typically you're going to have and particularly if you're not doing pre-suit skip tracing, which most firms don't and probably should. Most firms do, but they may not do it as aggressively as they could. We find that a good 40 to 50% of the ones that we're given, the addresses just aren't good. Mm. With a client that does more aggressive skip tracing before we get it, it will be a higher number that do get served. But let's go with like 40%. On a good client, it might be as low as 20-30%. But of those, when they come back, about a third of those we would be able to identify and serve at a new address, a new second address in effect, and that's in venue. We may identify a lot more that are out of venue, but that's going to then have to do an additional process. You can't just proceed with that due to the FTCPA rules. On most collection litigation, if you're doing commercial litigation, that wouldn't apply, but with consumer litigation. So, when you're talking about as much as 40% and then you get a third, you can get a lift of 15 to 20% just from the skip tracing that's in that's actively placed with a process server. Then on the third bucket of where it's unable to serve inventory, non-serves, at any given time that you do that, it's going to change because it changes over time. So new addresses will pop up 2 months from now that you may not see today. So at any given time that you're doing that, we see that you can identify another 15, maybe 20% each time that you do that. If you do it, let's say every few months. And of those, once again, about a third will serve. So you can get as much as you could get a 5% lift just from doing that post-service, non-serve litigation. And if you do that on a regular basis, I mean, you can increase your overall your service rate by a meaningful amount that it's worth investing. I always believe that if you've got cost-effective skip tracing, it's always a win because you add up what you're gonna what the liquidation benefit is versus that investment in the skip tracing. You're always going to win. It's a time game, of course. You're investing in the skip tracing at one point in time, and the liquidation dollars come at a later time. But it's if that time game is not a problem for you, you're almost always going to win unless you have really lousy skip tracing.
Yeah. So a couple of things, and I'm glad you mentioned that. So the FDCPA, I know we touched on it, but for the folks that might not be so familiar with it, so the FDCPA regulates how debt collection is supposed to be done and be done with the appropriate compliance. So you have to sue the consumer either where the contract was entered or where they reside. So it's not just that obviously the case can't be move forward until you effectuate service according to your state's rules. But for this area of law, there's two different specific. One is, complying with the court rules and having service done appropriately and ethically, and being able to document how you did the service. But also at the same time, you could have really, perfect service. You had the right address, you had the right consumer, person got the documents. They can even say they agree that they owed the money, but still you violated a compliance law of serving them at an address that is inaccurate or wasn't accurate, or you picked the wrong county. So there's a lot more to this, is what I'm hearing, than just go look up this person's address. And so that was the first thing that I really glad that you pointed out. But my other question is, and you kind of touched on it, is so you go through the whole process and you for whatever reason, you can't get good service. The person's not there. And many times, sometimes it's I'm not saying this is a common thing, but it does happen where the person you're trying to serve is maybe, on purpose making it difficult to find them, avoiding service or things of that nature. So the question then becomes is, how many times after the initial try do you think people should go back and skip trace it? I think you mentioned, is it a good use of your time and money every 2 months, every 3 months? Like how would you advise someone who's saying how often should we do this?
I think that's a very good question. And it depends on your, once again, your cost of your skip tracing and also the size of your pools. And also, I think, you have to be very cognizant of when the statute of limitations is going to run, or when your client is going to recall the accounts, if you have some knowledge of how that works with your particular client. So, with our clients one thing I should mention, but to back up, is in ProVest's case, to save our clients the skip tracing costs, because we do tons of skip tracing, so our costs of skip tracing are pretty low compared to our clients' cost of that. So we generally will do the skip tracing at all three of those points that we talked about at no charge for our clients, because we tie it that we'll do that, but any work that then moves to an address that we find, we want it to come to us, and we charge an additional process serving fee on that, but we don't charge for the skip tracing. So, and I think there may be other process serving companies that may do that, others may not. But in our case, we try to encourage our clients to skip trace through us, and then we want obviously the work to flow. But in the case of the inventory that's non-serves that goes back to our client, and I mentioned you keep a track of the statute of limitations, when you could have a recall, what all of those kind of things. Our clients are typically doing it monthly or quarterly through us. And I think that it depends on, I think the key thing is the law firm has to then process that information. So we can do the skip tracing of it and give them, here's the new addresses we find. They have to then have processes to review that, and then potentially have to cut new documents if they're in new venues, or do alias documents in some states. So it's not so simple as, in some states like Georgia, you can just, if it's in venue, you can use the old documents and they take a real long time to expire, for example. But in other states, that's not the case. So you have to, I would say you have to have it at the rate that you can absorb the information. So, and what your processes of handling that are. Some firms are very automated where they can take addresses and everything moves pretty quickly, and others are not. So it all depends on that. So we always tell people, do it at the pace that you can absorb it, and and if it's monthly, it's monthly. If it's quarterly, it's quarterly.
And another thing that you mentioned that when I was in the trenches, so to speak, doing this kind of work and doing the debt collection litigation, I initially thought, well, the technology is the same for everybody. So, sort of, what's the difference? What company I use? What's the difference? What skip tracing I use? But then, after many years in the industry and doing this on a regular basis, I realized that wasn't accurate. In fact, old inventory that the company that we may have been using couldn't find any location. Lo and behold, we just transferred it to another company, and they were able to find good addresses. So I think that's also a good point that people should realize, is that companies like ProVest that are this is their business, this is all you do, is not the same as some other tools or other things that are used to find addresses. And I really found that there's a difference when you use a reputable company that understands the nature of the work. That's just my own my own experience. So I'm glad that you kind of mentioned that it's not all the same, and it's not really as simple as it sounds, because there is liability for making mistakes in this space. So anyway, so that brings me to my next question, and the bottom line is always the bottom line. Does a higher service rate always equal more revenue, a higher liquidation rate for your clients?
It should, but you have to, aside from all the things not related to skip tracing, which there are many, but looking at it from your question from the skip tracing standpoint, it depends on the cost of the skipping. So if you're paying that out of pocket, it may be different than if you're using my company. We do it at our cost. You have document preparation costs. You then have the service costs of that. So, I mean, you have to have all of that factored in as to, whether that makes sense or not. When I discuss it with firms, they generally feel it's worth the investment of doing that, but it all depends on each firm's situation in terms of the economics of it. But generally speaking, there's a pretty good correlation between a higher service rate and a higher liquidation rate.
So again, and clients are cognizant of that. In other words, the law firm's clients take a look at these kinds of numbers and have certain expectations based on industry norms. So it is something for law firms, especially those that represent creditors, to keep an eye on these kinds of service rates. It is something that does drive the entire sector. So we're getting close to the end of our cup of coffee here, and I know that I'll have you back because you've been a great guest, and this is like our third or fourth time we get a chance to talk about um, process of service and those issues. So what's the final word from Joel today?
Well, anybody who's has any questions or whatnot, feel free to reach out to us. We'll be happy to give, consultative comments to your particular situation. Always love to chat with people. We will also be, if you don't get the chance to do that, we will be at the upcoming NCBA conference in New Orleans in October, which is going to be a very big and exciting conference, but we'll have a booth there, and I will be there personally. I'll be glad to meet anybody or speak with anybody there if they have questions on this or anything else related to process serving. And as always, Nathan, it's a pleasure to have the opportunity to participate in these educational coffee breaks, and thank you for the opportunity.
It's our pleasure. We really appreciate the support of ProVest, and Joel, you've been a real friend of the industry and NCBA for many, many years. And thank you for giving a shout out. It's going to be a really great conference. This is going to look like the pre-pandemic conferences. The registrations are rolling in. It's going to be in a great location, great venue. So anyone listening, if this is your space, don't miss out. It's going to be the place to be for the Connect conference in New Orleans. So with that, thank you for joining us today, and we'll see you on the next episode of Coffee Break. So thanks, everyone. Have a great day.
Thanks, Nathan.